question is this valuable? Does it have value outside of World of Warcraft? Does it have value outside of just me being able to listen to my songs that I care about? And we, as Americans at least, have a very long history of being able to take our stuff that we own, our property that we own, and be able to give it or sell it as we wish, right? And this, goes back to CDs, right? If I have a CD, I don't listen to the CD anymore. I want to sell it to somebody else, right? I'm able to do that. Or if I want to give it to somebody else, I can do that. Books, same thing. Anybody who's gone through college knows that books are expensive. It's much better to be able to buy a used book than a new book, and it's much better to be able to sell that book to somebody else and then recoup some of the hundreds of dollars you've lost or thousands of dollars on the secondary market. Same thing with DVDs, and you do that on eBay, Amazon. You do that at ye olde bookshop, right? Those bottom right are very few and far between these days, but you can also do it that way. So the question is that analogous? Is that an analog to being able to do that in digital copies? Can I sell my iTunes songs? Can I sell my ebooks? Can I sell my MP3s, my videos? Can I do those things? And that's a big question. And most people who were asked that question would answer, yeah, of course you can, right? Why wouldn't I be able to? And the answer is probably not, and we'll go through that in a second. And this is becoming increasingly important because we, as consumers, have gone away from physical CDs, obviously, away from the physical realm and going into the digital realm. For example, music, and we're talking about downloads here, and again, we're setting aside Spotify, the Spotify or Google Play All Access and all those other all-you-can-eat streaming services. That we'll set those aside. But just downloads alone, that's almost $3.5 billion last year. That's each year, $3.5 billion. Digital sales have now surpassed physical sales of CDs, so that's pretty amazing. Ebooks, $2 billion, so not quite as much as music, but still a big deal. It's now, of the formats of the hardcover, paperback audiobooks, it's the most popular format. So that, of course, is going to increase in time. Movie downloads, you have 3.4 billion, you have 2 billion. It's only about a fifth of $1 million. That's not very big. But of course, how often does one watch a movie multiple times, right? How often does one feel like you need to buy the movie when you can just have Netflix and be able to watch it whenever you'd like? So of course, that's not as big a deal. And online views now have exceeded online purchases, I should say, have exceeded physical purchases. So when you think about whether one can either sell or give away one's digital assets, you have to think about this as a three-legged stool, right? There's an interaction between three items. The first leg is technology, right? What the technology can lock down or otherwise. The second leg is through contract, and that's arguably the most important leg that we're going to talk about. And the third is through copyright. And I do a lot of copyright law. I'm teaching advanced copyright at William Mitchell College of Law right now. And that's also a big stick that can be used in answering this question. So let's talk about that first, one that's near and dear to the hearts of most people in this room, and that's the technology aspect. And the technology is the biggest stumbling block that is going to affect the contract and the copyright law. And the reason for that is with physical books that I bought as a at the used bookstore for college, if I buy that copy, I give you that copy, I don't have the copy anymore, right? That physical book goes from one to the other. And if I can make a copy, I can go to the Xerox machine, but A, it's imperfect, and B, it's a pain in the ass, right? So why would I go through that when it's relatively cheap just to buy it on the secondary market? Contrast that with electronic books, right? So you can make unlimited, identical, perfect copies, and I can give you that book, but I still keep the book myself, right? And of course, that idea is terrifying to publishers, terrifying to copyright holders, and that's what they want to avoid. And when we talk about, the reason we can sell books, it's because we couldn't do this until recently, right? So that's why it's really difficult. You might say, well, okay, well, what about if I give you that copy and then I delete my copy, right? Shouldn't that be okay? Shouldn't that be fair, right? Because I don't have the copy anymore. Now they have the only copy in existence, right? That's been argued. And it may have some legal weight. But the problem is, how do you make sure that the seller actually deletes that? How do you make sure that that happens? Or if they just say, yeah, I deleted it, right? Maybe they did, maybe they didn't. So ways that, of course, the companies have tried to counteract that keeping a copy problem is that they've enforced DRM, digital rights management. They put locks upon the digital content, so you can't copy it, you can't transfer it, you can't use a DVD you bought in Asia in the United States or vice versa, right? And so DRM is, of course, a blanket term for a lot of a lot of different locks that one can put onto technologies. And here's just an example. Fair Play, iTunes, until 2009, then they got rid of the DRM because it was more hassle than it was worth. Same with movies, same with ebooks. There's a lot of DRM out there, as anyone who uses consumer technology knows. And so the thing with DRM, in addition to contract, and DRM in addition to copyright, is that even if the companies don't have a legal right to prevent me from selling it to you, they may have the technological right to be able to keep me from doing that. They may lock it down to make it illegal, or make it, if it's not illegal, make it at least impractical to do such things. So the biggest problem, at least I can see with DRM, is that DRM is created by companies, and companies can go away. Or the companies can move on to different technologies, as often happens. So what if that company that created the DRM for the ebook I purchased, all of a sudden, what if that company goes out of business, right? And I have this book now that I used to have to ping a server to be able to let me read it. What if that server is no longer in existence, and I bought this thing for 15 bucks, and now it's not worth the digital paper it's written on, right? Then that's, and this isn't just an academic question. This has happened time and time and time again. All of these DRM have gone away. And so consumers are often left holding the bag, or holding the inconsequential digital aspects of it. And there's no reason to believe that this problem is going to go away any soon. And as good techies sitting in this audience know, well, DRM, really. I mean, I can get around that in 20 seconds, right? And it's true, you probably could. Whether it's legal to do that, though, is another question. Because under what's called the Digital Millennium Copyright Act, it's a 1998 law, and it says that it's a federal law saying that one cannot break DRM. One cannot circumvent a digital rights management system. And that's separate and apart from copyright infringement. They've written certain exemptions into the provision, but those exceptions arguably don't apply to the areas that we're talking about. So the proponents of the DMCA, essentially the Disneys of the world and the large copyright holders, have said, listen, we need DRM to be able to protect our works, because if we didn't protect our works, there would be, somebody would buy one, and then it would get distributed by the millions. We'd go out of business, right? That's what the proponents are saying. And the critics are saying, well, listen, if you lock up this video, and I wanted to make a commentary on that video and use a snippet of it, I should be able to do that. That's called fair use. But because you've locked it down, I can't take that snippet from the video and use what is arguably my right under the law of fair use to be able to use it. So that's kind of the push and pull with the Digital Millennium Copyright Act. And again, like I said, the DMCA prohibits breaking, and you can't really see there's a crowbar, right? It prohibits breaking the locks, and you can't sell devices that would break the locks. So both of those are offenses. And you could say, well, of course, I can go over to an overseas server and buy those things to break the locks. But again, even using the lock arguably would violate the DMCA. So there are exceptions to this DMCA law saying you can reuse some video excerpts. So the example I said before, if I wanted to make commentary on this particular very short slice, I would have a good argument that that would be fair use. If I wanted to caption it, there's a movie that doesn't have captions. If I wanted to aid it, help people that are hearing impaired or otherwise by creating captions, the Library of Congress, who creates these things, say, yeah, you could do that. Ebooks, if I want to arguably make a readable version for people who are hearing impaired, assistive technologies, you might be able to do that, or visually impaired, and make it audio. And if I want to jailbreak smartphones, you may have seen this in the news that they had this exemption for many years, and then they took it off the exemption list. So it was, again, illegal, arguably, under the DMCA to jailbreak your smartphone. There was an uproar, and now that's changed back. And so now, again, you can jailbreak smartphones. Importantly, what is not listed is that it is not an exemption to break the DRM to sell your items. It's not an exemption to give away your items, and it's not an exemption to transfer those to your heirs. It's not a big deal now because a lot of people that are passing away have large album collections, right? They have physical LPs or otherwise that they hand down to the next of kin. But you can imagine that as digital downloads of music, audiobooks, et cetera, go on, there's a lot of money stored digitally that one might think that I could transfer on to my kid. But it is not an exemption to be able to break the DRM to transfer it to your heirs or devotees. So the first leg is technology. The second leg is contract. And the contract arguably is the biggest stick here, because even though you have a right under copyright, you may give away that right under contract, or you may bolster that right under contract. So if you buy anything from Apple, a book, music, etc., they say that this license, the most important thing with this terms of use and terms of service is that you don't, when you click buy on Apple, Amazon, iTunes, Google, etc., you don't really buy it. You don't buy the thing. You merely buy a license to read the book, or a license to listen to the music, or a license to watch the movie. And that distinction, not buying the thing, when you buy a CD, you buy the physical CD, right? But with these digital downloads, you're buying a license to be able to watch or listen to or view these things. So that's a very big distinction. So for example, Apple, this license to listen to music, for example, is non-transferable. You can't, any other use may infringe copyright. They say that right in the terms of use that you clicked on OK that you didn't read before you went on to the next thing that you did. Same thing with Amazon. We grant you a non-exclusive. That means that it's a non-transferable right. You can't transfer this right to read this book to anybody else. It's for your personal use. So my wife arguably can't read my ebooks, right? You may not assign, you may not share. I can't share it with my wife. I can't lend it to my wife. I can't otherwise transfer this music content to anybody else. We don't grant you any of these distribution rights or any of these things, right? So this is all in Amazon. Similarly, Google Play, you must keep your user details secure. And you might argue, well, what if I just give my wife my username and password? She can listen to the Google Play music. That'll be great. But under Google Play's terms of service, at least, you must keep your details secure. You can't share them with anybody else. So I would arguably be violating the agreement that I agreed to when I clicked OK, after I'd, of course, read every single word that was in that user agreement. So the terms of service for online accounts, if someone else obtains my username and password, say if my wife sees my username and password written somewhere, that might be violating state and federal law, or both, right? So there's the state criminal statutes regarding unauthorized access of computer accounts. There's the Computer Fraud and Abuse Act, that's a federal law. And then there's the Stored Communications Act, which is another federal law. So the state side, a lot of them say you cannot unauthorized access to computers, you have to have an intent of fraud, ID theft, hacking, stuff like that. So, and you might say, well, what kind of prosecutor is going to prosecute my wife for accessing my music, right? Maybe not. But if you live in California, yeah, maybe. Computer Fraud and Abuse Act, this is the federal law. Again, it's intended to prohibit hacking. They don't want people to hack in. So the penalty is 1, 5, or 10 years, or a big fine for unauthorized access to a computing device, right? So maybe is my Amazon account and my wife getting unauthorized access because Amazon didn't authorize her to go into my account, right? It depends, you know. These are difficult questions to be able to answer. So this is a way of saying that if you have a contract under the terms of service, plus the DRM, the digital locks that you can't circumvent, often they have a greater value than the copyright that we have. And again, this unilateral non-negotiated aspect, I mean, I can't negotiate with Apple to say, oh, listen, this is kind of excessive. I really want to be able to share these things, right? That's not going to happen. You can't redline the contract. And then DRM, at least with the ebooks and with videos, that enforces those contracts, or it might go beyond even enforcing those contracts. And then that might well exceed the copyright protections that those content owners are entitled to under the copyright statute. So let's go on to that third leg, which is the copyright. And particularly the one that is most important for what we're talking about today is the first sale doctrine. So the first sale doctrine has a long history, and what it means is that if I buy a book, I can sell that book to somebody else. Okay, that's got a really long history that used to be enforced what's called judges, a common law, which is what judges said. Now listen, you a copyright owner can't sue somebody for selling the book to somebody else. We're not going to let that happen. And that was enforced by the U.S. Supreme Court in 1908. And that's what happened was the publisher, this company decided that. They were going to sell books. They're a bookseller. And the publisher, what they did is they put in the inside cover, by purchasing your book, you're agreeing by license to never sell this book for less than $1 or whatever it was in 1908. And then when this guy sold it for less than $1, they sued him, went all the way to the Supreme Court. And the Supreme Court said, listen, you can't make somebody by a contract, make them not be able to sell books, right? The person who buys the book doesn't buy the copyright to the book, but they at least have the ability to be able to sell that book to somebody else after they finish. So that's the first sale doctrine. That was then codified by Congress. It was a judicial standard, and then it got pushed to the Congress in 1976 through the Copyright Act. So now it's written into the code saying the first sale doctrine is alive and well, or at least it should be. So then the good thing from a public standpoint is that leads to cheaper alternatives. This leads for us to be able to buy used CDs for $3 rather than the new CDs for $15, right? I can buy my used books at college. I could buy used DVDs, and you can get them at any sort of venue. You can get them from eBay, Amazon, etc. But the question is, now that we're moving away from these physical realm, where the courts and statutes have clearly said you can sell these, can you do these things for digital content? Can I either sell them or can I give them away, right? And another question is, can these copyright holders, the people that own the content, can they get rid of the secondary markets, right? If you think about eBay, they're doing pretty good trade in buying, making it able to transfer physical goods. Sotheby's, that painting he's selling is a copyrighted work, right? But it's the copy of the copyrighted work that they're able to sell, again, under the first sale doctrine. So would somebody be able to, by contract, prevent such things? It's a good question. And a big thing is if somebody dies that has a library of 10,000 books, often what the kids will say, I don't have room for 10,000 books. They donate it to a library, right? What happens when I have 10,000 ebooks, right? Does that value just go away? How do libraries do interlibrary loans when the physical book is easy enough to send it? What if the ebook, I'm prohibited by license to be able to transfer such things? There are also archiving, accessibility, how to let blind people be able to get the content. There are all sorts of issues that are tied up in the digitization of content. Like I said, what if I die and I have $15,000 worth of music that my kid surely is not going to want to listen to, right? But it's still if I have $10,000 worth of CDs, I could sell them maybe for $3,000 or something that my kid would like. What if I have $10,000 worth of music? That goes away. So the contract and copyright tend to go back and forth as to which controls. And who knows about auto-match, for that if you have a CD that to be able to listen or otherwise be able to see things. So the way auto-match works is that if I have a CD on my hard drive, iTunes, Amazon, and Google Play will go and look at my hard drive, say, oh, you have that MP3, and they say, oh, it looks like you have Nirvana. Now you're going to be able to listen to Nirvana in the cloud. Okay, that's the way that works. And so then you might think, well, the recording industry, how can they let that happen? Because I have this copy here, and they're making a copy from there to there, and I thought making copies under the copyright law is not right. Well, they do that because the RIAA gave a license to iTunes, to Amazon, to Google Play, and they can only do that through that license, right? They wouldn't be able to do that on their own, but they've worked out deals with the record industry to say, okay, we'll be able to do this for the benefit of our customers. Similarly, Amazon created what's called the auto rip. So say in 1998, if I may have bought a Nirvana CD via UPS, it's shipped it, then that was in 98, and then 2013, I'm a bit older, Amazon will go down and they'll again see that I have that. They'll not see that I have it on my machine, but they'll remember, oh, that's right, back in 98, you ordered that from Amazon, right? You ordered that. So we remember you ordered that. So now we're just going to give you access to it in the cloud. Now you can listen to it in the cloud, even though we're not going to verify you still have the CD. And again, they do that because the contract side of it is interacting with the copyright side. They would not be able to make that copy under the copyright law, but they're able to do that through the license they made with the record companies. So here's a hypothetical. What if this were to happen? What if in 1998 I would have ordered this CD? What if I ripped it to my hard drive? Right? This is a hypothetical. What if I had ripped it to my hard drive? And then what if I had either given it away or sold it to somebody? Right? So now I have the MP3 in my hard drive. And then in 2013, then they go through, and even though I don't own the CD anymore, I have the MP3 on my hard drive, and they say, oh, you have the MP3 on your hard drive. We're going to push this over here, right? That doesn't seem right, right? Because I don't have the CD anymore, and that seems wrong. But you can be certain that, and I don't have firsthand knowledge of this, but it's rumored, at least, that the RIAA knows about this, right? And they've given license to account for this kind of thing. So, and again, what if this auto rip happened? Hypothetically, if this maybe might have happened, I'm sure it has happened to somebody. 1998, you buy a CD through Amazon, you give it away as a gift without even opening the wrap, right? So you don't even have the MP3 on your hard drive. And then in 2013, Amazon gives you the right to be able to access that CD that you never even opened, that you gave as a gift to somebody. Again, they can do that because the RIAA gave a license to them to be able to do such things. So again, there's a combination, the three-legged stool of technology plus contract plus copyright kind of go together in this way. So there should be a law against such things, right? And there has attempted to be a law against prohibiting digital first sale, prohibition. That's a lot of negatives. So there should be a law saying that I should be able to sell the digital stuff I own. In 1984, there was a lot of concern about, just like we have movie, DVD. Remember Blockbuster? Anybody remember Blockbuster? Yeah. So they were worried about having an audio equivalent of Blockbuster where they would just give away tapes, right? And they were worried that people would be able to get the tape, go home, and then use those tape-to-tape recorders, and then be able to have free ones. So in '84, they said you can't rent recordings. The same thing in 1990. They thought, oh, geez, what if somebody had rented out Microsoft Office and then just made copies and returned it the next day? So they made in 1998, they did that. In '97, they tried to codify. They tried to make a statute permitting digital first sale. So these are forward-looking legislators. They proposed it, but of course, Congress never does some things quickly, and it just died on the vine in 1997. Fast forward to 2001, where the Copyright Office, which decides a lot of these things, did a white paper talking about whether there should be a digital first sale doctrine. And the short story is they said, no, it's not. If there is going to be, it's not going to be from us. And there's a lot of reasons why. They say that first sale shouldn't apply digitally. It applies to paper because there is a physical atomic thing that you're handing from one to the other. That tangibility is what defines the first sale doctrine. When I give something to you, I don't have it anymore. Those atoms go away from me and go for you. And with digital, that's not the case. So that's what the Copyright Office says. And the second, people said, well, but I like my eBays, right? I like my used bookstores. I like my secondary markets where I can buy cheaper things. Shouldn't we as a government encourage such things so that the consumer is able to benefit? And they say, listen, that's not our rule. That's not for the Copyright Office to decide. That's for Congress if they want to decide. So we're not going to support it for that. There's no guarantee of these secondary markets. So the DMCA, they said, well, what about the DMCA? This thing where you prohibit it, the companies lock it down, we can't break the locks, that just seems unfair. And the Copyright Office opined that the digital locks, the DRM is not the problem. What the problem is the other leg of the tool, that's the licenses. So even if we let you unbreak the locks, the licenses would still prohibit such things. And we, as the Copyright Office, are not going to argue against the contracting of two willing, and people entering into the contracts. So in 2001, they said, we're not going to get involved. The marketplace will sort it out. If the consumers want to be able to sell their things, they'll buy things from companies that will permit such things. And if the consumer would prefer to have a much easier delivery system like Amazon, where there is DRM, so be it. That's for the marketplace to decide. That's not for the Copyright Office to decide. So that was 2001. That's in the United States Copyright Office. Fast forward 11 years to the European Court of Justice, and they, when they were asked the question about digital first sale, they said, oh yeah, we're going to let that happen. And this is in the context of software. And they say, as long as the license you entered into with your software, right? So if I buy, Microsoft widget, right? And that Microsoft widget doesn't say that I am able to use it for 5 years or 10 years or something. If there's no time limit on the amount of time I can use this, then that means you own it, right? And own it in the truest sense, not in the iTunes sense. And then the first sale applies. So I can sell that software to somebody else. That's what the European Court of Justice said in the European Union. And that through, you cannot prevent that resale of that software. But here's the big thing that the EU said. After I sell that software to somebody else, I have to delete it from my machine. That's the important part. They said that we can't have multiple copies going over. There has to be at least only a single copy out in the wild. And the software company said, come on, how are we going to enforce this? How is this going to be, are we going to have the software police coming into each individual computer to make sure that they deleted this off their machines? And the European Court of Justice said, well, you have the same problem with CDs and DVDs, people, right? I mean, when I sell a CD to somebody, do you go to somebody's hard drive and say, well, did you all those MP3s you ripped, did you get rid of those, right? And nobody does that with CDs or DVDs. We're not going to do it with software either. So the question is, that's the rule in the EU, at least as of now. Would that be able to work here? And the answer, it seems, at least now, is no. It won't. There's a near and dear, I'm sure, to a lot of software developers' hearts is anybody use Autodesk or know what Autodesk is? It's a CAD program. So there was in California, in the federal Ninth Circuit, there was a dispute as to whether somebody could sell. They bought Autodesk. They wanted to sell Autodesk, and they wanted to be able to sell it freely. Autodesk sued, saying, no, under the license, you aren't able to sell it to somebody else. And the Ninth Circuit said that the software company is right. Autodesk is right. You, the purchaser, signed an agreement saying you wouldn't resell it. You were trying to resell it. That's breach of the agreement. So you cannot resell this software. And it's not a big leap of logic to say, OK, sale of software versus sale of music. The terms of service, we've talked thus far about software, but what if it moves to glass, right? There was a big deal with when this first came out that they said somebody tried to sell them on eBay, right? You buy it for $1,500. They tried to sell it for $3,000, $4,000 because it was such a limited quantity. And Google cracked down, saying through the terms of service that your Google Glass purchaser agreed to, you agreed you would not sell this, right? And that's a big shift, right? We've been talking about selling software, digital bits, but it's another thing to apply that license to physical hardware that you can give to another person. And you might argue that this physical hardware that I have is useless without the software to run it, right? If there's no software there, it's just an ugly thing that people make fun of you for wearing, right? And who would want to spend that kind of money for something that people make fun of you doing? But it says you may not resell, loan, or give away this to any other person. Then they reserve the right to deactivate the device, again, taking away that software element, and nobody else can use it. So that's, again, nobody sued over this. This hasn't been tested, but this is a bold move by Google that I haven't seen before. There's another more on point. There's Redigi against the RIAA. Anybody know what time the session ends? I don't want to go over time.
Oh, 3:30.
3:30, great, I have 20 minutes. So Redigi is a company that tried to be the eBay, is trying to be the eBay of digital music. And certainly if they are succeeding in digital music, they're going to go on to ebooks, movies, et cetera. So what happened is so you have the RIAA, you have here's the owner, and you have also the seller. What they do is they upload the file to Redigi. And what Redigi tries to do is to replicate the physical transfer that I had with the book earlier. So they transfer it so the owner transfers it to Redigi. It's stored on the Redigi servers. The buyer will then download the file from Redigi servers. And then through Redigi software, Redigi, what they say, oh, I see. Sorry, so I've started with the RIAA. The RIAA alleges what happens is the owner transfers it to Redigi. The owner keeps a copy themselves. Redigi gives a copy to the buyer. Now there's two copies. And is the owner keeping a copy? The RIAA says, yes, the owner is keeping a copy. This is copyright infringement. They shouldn't be able to do this. Now contrast that with what Redigi says, right? So Redigi, now they're in the envisioning side. They're saying, OK, as I'm transferring it from the owner to Redigi, it disappears. And they argue, and some of you tech folks can see whether this is legitimate. I don't know if it is, but they call it a molecular transfer. So they're saying it's a bit by bit. They're pushing. So at any given time, any element of that ebook or music or whatever is being transferred over the interwebs to be able to go to Redigi. So there's only one file, or even one little tiny piece of that file in existence at any given time. And then see what happened there? So when the buyer downloads it, they not only download the file, but they also download the license that the seller agreed to when they bought it from iTunes. Okay? So this is the way Redigi was arguing it happened, in contrast to what the record industry was arguing. So unfortunately for the Redigi, the district court in the Southern District of New York didn't agree with Redigi. They agreed with the record industry, said that they granted what's called partial summary judgment, which is finding for the record industry against Redigi. And they said, now, this is a really interesting question, which it was, the district court said, as can I purchase digital file, can I resell it under the free sale doctrine? That's what we've been talking about. And Redigi, in addition to the molecular transfer I talked about, they also said, and the judge was not a young judge, okay? So they were making analogies that may or may not be apt, but they were saying, listen, judge, this bit stream is like a train, right? And the train moves from the owner to Redigi, right? So it's just going along. So that, you know, just because a train goes from Minneapolis to Chicago doesn't mean that the train is in both places at the same time. So they said no. The court said no, that's not going to fly. They said, you know, we're going to focus on the physical object. Redigi is making a copy. They're not transferring that copy. They're actually making a new one. This is the most disturbing from a technology lawyer. This is the most disturbing part of the decision, saying the court says that a digital file on a new hard disk is a reproduction, a copy, under the Copyright Act. So what he seems to be saying is that when I buy my, my iTunes song and download it to my home desktop, my ripping or transferring that to my iPod is a copy under the Copyright Act that may violate the Copyright Act. Seems wrong, right? And the courts have actually held that that's wrong, right? But he seemed to say that. And he says that if somebody wants to sell that file that they downloaded, they're able to do that. They just need to sell the desktop hard drive that they originally downloaded on, right? Just a bizarro. And Judge, if you're listening, I'm not saying you're bizarre, but I'm just saying that maybe your logic may need some tweaking. But it seems as though that is not at all would not square with anybody who knows technology in the 21st century. So at any rate, any of these would be arguably infringing uses, right? If I download to any of these, you know, we can these days read an ebook anywhere, we could listen to music anywhere. It doesn't matter what initial device we downloaded it on. So the question is still going on. They've appealed it now from the district court to the Second Circuit Court of Appeals. If they lose there, they may well appeal it to the Supreme Court. So it's not finished yet. The founder and CEO of Redigi, interestingly, got appointed to the Congressional Internet Caucus Advisory Committee to talk about the way that commerce should work on the internet, right? So he's got the ear of Congress, at least on this. So you can bet that he's going to be making some interesting arguments before them. Also interesting is, you know, Redigi almost nobody's heard of, but Amazon, you may have heard about Amazon. Yeah, you've heard about Amazon.com. They filed a patent, and just because you file a patent doesn't mean it's going to go to market. But it's still interesting that they filed this patent on digital resale, and the United States Patent Office, USPTO, granted the patent. And what the patent is for, and this may look familiar to you, is for the owner being able to transfer to Amazon, and then deleting from the seller, and then everything going to the buyer. So the Amazon, which is a huge, huge company for selling content, right? They sell ebooks, they sell music, they sell videos. They've gotten a patent for this. And you can get a patent for something that you're never going to use, right? So just because they've gotten a patent for it doesn't mean that it's necessarily going to happen. This is a bit different than what Redigi said. Amazon is saying that the patent they have is totally different than what Redigi did. You know, just because the district court said that that's not what we do. They say, you know, what Redigi does is they do this molecular transfer. We're not patenting that, and they do it that way. So. If anybody who's ever bought an ebook from Amazon knows that certain publishers will permit, again through contract, this is not under the copyright leg, but it's under the contractual leg, they permit lending from one person to another. So the way that they do that is that if I want to lend my ebook to Sam, and Sam, when Sam's reading it, I'm not able to read it, right? So they do that through DRM to be able to lock those things down. And again, that's done under copyright. I'm sorry, it's done under contract, not under copyright. In addition, there's also, in addition to Amazon, you also have another big company that has also filed another copyright. It's not yet been granted, but they filed it last year to manage access to digital content items. And they say, you know, this is for managing ebooks, music, movie software, et cetera, to transfer them from one user to another. Again, looks pretty familiar. So when the big 800-pound gorillas are getting into the game, there might be some legs to it. So that's one argument, saying, OK, this is actually something that actually is going to happen. It just takes time, right? The counter argument to that is, well, maybe they're getting patents on it so that they can exclude anybody else from getting into that game, right? Maybe they want to keep the status quo, right? So there may be a defensive patent to be able to keep people out. So there's a back and forth as to whether this is actually a harbinger of good things to come, if you're on the side of being able to want to freely transfer, or whether it's a harbinger of it being dead in the water. That still remains to be seen. And it's often decided, as you know, by the courts, the way the courts come out, or the way Congress decides laws. And you know, everybody knows that Congress is doing a great job with passing laws, so I'm going to count on them to remedy things.
Fast and efficient.
Absolutely, without much arguing or bickering in between. So the big question, as I've been considering this, I've written a couple of articles on this, and I wonder if the days of downloading an iTunes song and wanting to sell it are just a little slice of time that is not going to matter anymore. You know, if you think about the physical copies that lasted for 100+ years, and then digital downloads have only been around since 2000, 2001, around there when it became popular. And since 2012, 2013, Spotify came on the scene. Now you have Google's All Access, you have Pandora. Since I'm a Google All Access player paying $10 a month, I used to spend $20 or $30 a month on music, right? So now I've shrunk that down to a third of that, and now I can listen to all 20 million songs or whatever they have in their database. I have not bought an album since then, right? So I've not had this issue of having an album that I purchased that I want to sell anymore. So this thing that I've become up in arms about, I wonder if it's just going to be obsolete. And I wonder if my kid's even going to care if I'm all up in arms about owning this thing, this ebook. He's going to say, well, how can you even own copyright content, right? This is just something you use for a little while or pay somebody to do it. It may not even matter anymore. So with 4:30, is that or 3:30? Is that 3:30? So we have 10 minutes left. Remember the three legs, because this has not only, for a lot of areas of what you do, the technology plus the contract plus the copyright, they work together. And one leg may be stronger than the other and may bolster it where the other might not do on its own. And they all govern this ownership, or whether you own it or whether you don't own it. All right, so we now have 10 minutes to talk about whether this is the dumbest thing in the world that the courts and everybody is doing, or whether it's a good idea.
So the contract portion of that,
Yeah.
terms of service,
Yeah.
like how enforceable is that in practice? Like, is it? I mean, I don't think the layperson, anybody reads any of the things they agree to.
It's a legal fiction.
Lawyers think that people read them.
Well, and so that's there's a fun thing that judges talk about, and they do talk about a legal fiction. That's a term that they use, saying that it's a legal fiction that if you sign the dotted line, it's assumed that you are going to be reading the entire thing above. As a practical matter, judges, lawyers, everybody in the room knows that people don't, right? But you can imagine what kind of strange thing, the mass chaos would ensue if a big company contracts with another big company, and then big company B says, hey, listen, I didn't read that thing above it. Why don't you strike out that side, right? So the legal fiction that is in place in this country and many other countries around the world is that if you sign it, you agree to everything, whether you read it or not. And so that puts the impetus on the person signing to make sure that they understand and agree to every particular provision. And so even if people may not do it, it's a legal fiction to assume that they do. Other questions?
So like lately, it seems like all my friends are talking about the whole HBO Go thing, how we're all sharing passwords, and I share my Amazon password with my husband, reading each other's books. How much do you think things like that are going to get enforced? Just people sharing logins to things?
It's a good question. And so there's a question as to how much it's going to be enforced as a practical matter and whether one can enforce it as a legal matter, right? So those two things may go back and forth. And you remember that the digital downloads, anybody heard about the Tammy, what is her name? The woman who got sued in Minnesota for downloading and distributing.
Music, yeah.
Right. So she.
Jamie Thomas.
Jamie Thomas, right. So Jamie Thomas was sued, and they had sued, the record industry had sued thousands of people, and that was the first one that went to trial, and it happened to go to trial before the judge that I clerked for at the Federal District Court. But that was the first one that went to trial, and it made a big splash, and it had a huge negative PR effect on the record industry, because they said, listen, she's a single mom. She was transferring, and this is in the early to mid 2000s, and she was trading Bon Jovi songs from the 1980s. I mean, how much actual value does a Bon Jovi song have, and 15 years later? So it had a negative effect. So even if arguably the record industry was legally in the right, they weren't practically. There were practical ramifications against such things. So that goes to your question as, people are sharing HBO Go subscriptions and usernames and passwords. There's the legal side where if I were to represent a large content company, I would say, now listen, you agreed during your terms of service when you signed up for HBO Go, you agreed that you would not share your password and username with anybody else. And this, the Computer Fraud and Abuse Act prohibits unauthorized access to our computer system, right? So under the letter of the law, there's a pretty good argument that you're violating all sorts of contracts and all sorts of federal laws. So you have that side of it, the legal side, and then you have the practical side. Is HBO going to want to go all out against its customers to be able to enforce those contractual or other rights that they have, perhaps perhaps taking a PR hit in the process. So that's, I think, the back and forth that happens.
Say I love the way, you can rent Microsoft Office now. You lease it, it's all online. They actually let you share it with 5 family members or on 5 computers. They give you the choice. I mean, because, come on, let's be reasonable. If I have a Netflix subscription and it comes out of our joint checking account, whose subscription is it really anyway?
Right.
I mean,
and that's
kind of a stretch.
And that's a really good point. And as we move to the cloud and we move away from the distribution on CDs or DVDs, those kinds of contracts, of course, are going to become more and more common. Those kinds of licenses. And again, of the 3 legs of the stool, there you're dealing with the contract leg. So as the content holder, Microsoft is able to give away rights of copying, of reproduction, of distribution. They're able to give those rights to whomever they'd like. And so by doing that, they're giving you the right to be able to make those 5 copies. So again, that's the way the contract differs from copyright. So yeah, I agree.
Well, that keeps me from being a criminal. I mean, like my husband has a copy on his computer for Microsoft, and my niece has a copy from school.
Right.
And I have 2 copies. I mean, that way I don't. It's like if they make laws like this, they're probably going to make more money. And at the same time, they stop us from becoming criminals.
Right, and if the world were like the Southern District of New York in the Redigi case is, right, that digital commerce as it stands today would come to a halt, right? Because you would never be able to, I mean, if your hard drive crashed, then you're out of luck, right? All that, the thousands of dollars that goes away, that's an impractical way. So, as tech companies, who are forward-thinking, they're at least starting to be forward-thinking enough to be able to, make reasonable copies. Whereas courts, which are often backward-looking, we as courts look at to precedent, so we generally aren't as forward-thinking as the technology companies are. We always play catch-up.
So you mentioned that you prefer to do the subscription every month, and then you download it, and your kids aren't gonna care one way or another. For friends, like my father-in-law, he has probably $2,000 to $3,000 worth of songs easily through iTunes. Would you recommend, that he that he rip those CDs that he does own, as far as giving them to his son, or you know what I'm saying?
Yeah, I do.
He does have thousands of dollars that he's paid for.
Yeah. That's a really good question. This question has been asked a ton of times. The nature of lawyer ethics is that I can't give an answer to that. But because I'm not your dad's lawyer, I'm not your lawyer. But what I can say generally is that a lot of people have thought about that. And what a lot of people have done is to make your dad to make a backup copy, right? And whether that's legal or illegal, people are doing it. And so then under the idea that their next of kin will be able to use those backup copies, whether that violates the law or not is right up to them and their lawyer. But that's one way that they're practically doing things. Another thing that people practically do, again, not giving an opinion as to whether it's legal or not legal, but what people are doing as well is using software like LastPass or 1Password or like KeePass and that sort of thing, and putting in their safe deposit box along with their will, they're putting something saying, honey, I'm sorry I'm dead, but here's, I subscribe to LastPass, here's my master password for LastPass.com. In it, you'll find all 500 of my websites, including all of my usernames and passwords, which, by the way, have all of my iTunes songs, have all of my ebooks, have all of my things. Honey, I'm not going to tell you whether it's legal or not for you to use them, but just as an FYI, here it is.
That's what some people are doing.
That's what some people are doing.
Yeah, that's actually what our lawyer had us do when we got married. Just to put all of that together.
And I won't put on the tape who your lawyer is, but yeah. But it's a dilemma because lawyers, to that point, I've talked to a lot of lawyers that deal with wills and estates and trusts, and they're faced with a dilemma because some lawyers, like the lawyer that you would talk to, will want to say this is what you should do, right, as a practical matter. But as lawyer ethics, we are not permitted to give legal advice that will break criminal or civil laws, right? And arguably, under the Computer Fraud and Abuse Act, giving somebody else your password could be unauthorized access that could violate this federal law under criminal penalties, right? So they're wary of giving the advice that lawyer actually did. Whether they should be wary of giving it, because it seems like a reasonable to a layperson, a reasonable practical solution to what is a difficult legal problem. Maybe they should be wary, maybe they shouldn't, but a lot of them are reluctant to give that advice. We had another question somewhere.
So, if I buy, say, a physical, copy, so if I buy a vinyl,
Yeah.
do I own the music or do I own the
That's a
vinyl
good-
object? Like if I
Yep.
record
Yep.
my records and store them digitally, is that?
That's a good question. So under the law, you own the physical copy, but you do not own the underlying copyright, right? So the underlying copyright is owned by the band or the band's label or whomever it is. You own the copy, so you can do with that copy whatever you'd like. The RIAA has taken the stance that if you want to rip that vinyl to digital format, the RIAA is saying that's a copy that is violation of the Copyright Act, and they're just saying it's in their they're just in the goodness of their hearts not suing you for that violation, right? So that's what they're arguing. We had another question.
Why did Bruce Willis back down from his Apple lawsuit threat where he wanted to will his iTunes collection to his heirs?
It's a good question. For anybody who didn't know, there was while this re-digi thing was happening, with Bruce Willis was a lot of reports were saying that he was filling out his will, had a lot of iTunes songs and content, and he wanted to make a big stink about him not being able to pass this along. Turns out that he recanted. He said, it was reported that's not true. I didn't actually want these things. It was just reported incorrectly. So I would have loved for him to make that fight. It's whether it was really not true or whether he didn't think it was a PR fight that he wanted to do since he works for content owners that pay his big salaries. That's another question. But yeah, I wish that fight would have gone forward. And it did, for a very short time, bring light to this tricky topic that has not had a lot of light to it. Other questions? Oh, I'm sorry. I'll go back behind you.
So what if a company that you have bought thousands of dollars worth of software for goes out of business? What are they required to do after that?
That's a good question. So if I buy software that goes defunct, it often depends. You will have. I assume that you had a license to be able to use that, right? And so it often depends on what that license says, right? So if there's often what's called a clause at heirs and devotees, or not at heirs and devotees, but successors and assigns, right? So they'll say if this company goes out of business, whoever gets those assets afterward, which may include the licenses that they had, go to somebody else, or they might go away. But that's an individualized question that you'll probably want to talk to your individual lawyer as to what the individual license or lack of a license means.
You used the example of Google Glass, and that seemed to go against the first sale doctrine. Do you think that that's legal and just hasn't been tested in court? And do you see other devices having similar license attachments?
It's a good question, because really, like I said, the physical copy has no value without the software copy. So where where it used to be a single embodiment, right, that was, you can't change the text of a physical book and then you can't do it away. But if you could imagine a scenario where the physical book, all of a sudden they took all the text out of the physical book and all you had was a paper that you can give to somebody else, right, that's a totally different matter. And so, I don't think the courts have really even thought about, and because they can't think about, the courts can't think about anything that isn't brought before them, right? They can't make a hypothetical, well, it seems like this is wrong. They have to have somebody actually sue Google Glass, or Google, about the Google Glass thing, and the odds of that happening are pretty slim because, you know, who wants to go against the huge money pot that Google has, and they have got a lot of money to throw to such things. And query whether Google actually wants to fight that fight either, because they would be arguably treading on uncharted waters. Other questions in the last 1 minute? Good. All right. Thanks, everyone. Oh, one more.
Thing. Do you think that the Creative Commons has any effect on this whatsoever? Because this kind of like just takes it another direction and says, you know what? Let's do copy left instead of copy.
Right. So the Creative Commons is a license. Again, of the 3 legs, they use contracts to overcome what they would not be able to do under copyright. So they say, if I create content, I'm entitled to be able to have that for the life of me plus 95 years, right? But I'm going to give away that right to do it, and I'm going to give it away for free through copyright, through that second leg, to be able to give it away to people to use for how they'd like. And so the question is, does that actually have any change on user behavior? And I'd say, yeah. I mean, all the Wikipedia stuff is copy left. I think Flickr, the default is that you will give it away for Creative Commons use. And within that license of Creative Commons, you can say, OK, I keep the right for, you can't make a copy for commercial use, but you can use it for non-commercial use. Or you have to give me attribution, right? So they can put different attributes to that contract. So I think the short answer, I think it is making a difference. Whether it's going to make any difference in this question, I don't think it will, because the Disneys of the world aren't going to let it happen. All right, thanks, everybody.